Hi, my name is Jamahl Kersey, and I'm a criminal defense attorney in San Diego. And one common question that I often get has to do with arrests and the effect they will have on one's record. More specifically, people ask, well, I was arrested, but I was never charged with a crime, and so will that remain on my record or not? And usually the way this comes up is in the context of applying for a job. So you apply for a job and then you submit to fingerprinting so they can run a background check. And either they run your federal background check or California background check or both. And then something comes out. And so the question would be, hey, I was arrested, whether it's in 1999 or last year or whenever it was, but the DA or the city attorney's office never filed charges against me. And so the logical thought would be, okay, I was arrested, but no charges were ever filed, so there shouldn't be anything on my record. Unfortunately, that is not the case. If you have been arrested, that arrest will always be on your record. And so whenever you submit to fingerprints and you pull that report, whether, like I said, it's California Department of Justice records or it's a federal record, that arrest is going to come out. There are some solutions to this problem. One of the solutions, which is the more easy route, is to have an attorney explain why there could be an arrest or there could be activity on a report. So if you've never actually seen one of these criminal history reports, basically it has the person's name, the date of birth, may have their address on there, their immigration status, or if they're a U.S. citizen or not. And then it'll have dates. It'll have dates and it'll state if a person's been arrested, it'll have the arresting agency. If the person was prosecuted, it'll say the courthouse that the case was processed in. If there's a complaint filed, it'll have the date the complaint is filed. If a conviction was entered, so a person pled guilty or a person was found guilty at trial, it'll have the conviction record. It'll usually have the sentencing date, and it'll have what the sentence actually was. So this information is very useful in terms of being able to find out what a person's criminal history is. But in the case of somebody who was just arrested and either the DA never filed charges against the person, or charges were filed and they were ultimately dismissed, or if a person went to trial and was found not guilty, this information is still going to come out on the rap sheet. In addition to, if a person ultimately gets their case expunged, that information is going to be on the criminal history report. And so these are common misconceptions that, oh, if I get my case expunged, it'll go away, or if I was never actually charged with a crime, it shouldn't be on there. This just is not the case. And so there's a couple solutions that we have to this problem. And so the first one would be for a person who is looking to apply for a job, we can help in terms of being able to pull that report and explain the context and contents in that report in order to ease the concerns of the prospective employer. And so especially in the instance where a person was actually arrested, but no charges were filed, we can explain, hey, this person was arrested, and people can be arrested for mere probable cause. But an arrest does not mean guilt. And so that over the years has been very effective in terms of being able to explain what these entries are on the criminal history background sheet, because it's not necessarily intuitive. These sheets can be very difficult to read. They often, they do have coded language. You have penal code sections, and then it's really abbreviated. And so for a layperson, it can be very difficult to understand. So we have been able to, put together letters explaining, hey, this was the situation, in order to help our clients ultimately get the jobs that they deserve. The other situation would be a petition for factual innocence. So this is the only way that you can actually have something removed from your record. So if there was actually no reasonable cause for your arrest, then you can put together a petition. Obviously, you would want to have a lawyer help you out with this, but a petition can be put together indicating that there was no reasonable cause for the arrest, and you would usually submit, any evidence that you have, if there were any photographs or videos, any witness statements, likely a declaration on the defendant's behalf, and any other information to show that there was no reasonable cause for the arrest. And so then there will be a hearing scheduled, at which time the judge would be able to review the evidence and make a determination as to whether there was any reasonable cause for the arrest. And if he finds that there was no reasonable cause, then he can issue an order, and ultimately that order would indicate that California, the Department of Justice, and the federal government would have to remove those entries from your record. So again, this is the only way that you can have something actually removed. So over the years, we've had quite a bit of success in both preparing these letters for our clients in order to put in context and explain what happened with our client's situation, or if the client is interested and the facts of the situation make it appropriate, filing a petition for factual innocence. I hope this was informative. I want to continue to deliver value to my community in the form of these videos explaining legal concepts and bringing to light issues that sometimes people don't understand but can be very useful to them. So if you have any suggestions as to other topics you'd like me to cover, please let me know in the comments below. Otherwise, we will see you the next time around. We'll talk to you soon.